Right. Um, Welcome to the January 15th, 2026 California Board of Behavioral Sciences Policy and Advocacy Committee meeting. My name is Chris Jones. I'm chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing the board's laws. Where the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. The committee will meet by teleconference in accordance with Government Code Section 11123.5. Committee members will participate remotely from private non-public sites. The public may participate remotely or in person at DCA headquarters at 1625 North Market Boulevard, Suite S 102, Sacramento, California 95834. I will announce when we are accepting public comment on the various issues, and the meeting moderator will open the lines as appropriate. Each commentator will have 3 minutes to comment. Moderator, would you please provide the audience with instructions on how they may participate during the meeting at the appropriate times?
Certainly, this is the moderator. At the times when public comment has opened, we will ask people to look for the raise hand icon, which is typically at the bottom of the WebEx screen if you're logged in through a computer. If you're on a mobile device, that hand icon might be behind the three-dot other options. By clicking that hand once, you'll raise your hand and be placed in line for the group who wishes to comment. We'll go one by one. As stated, each speaker will have 3 minutes with a 15-second warning. We ask people to stay on topic, and we will take public comment generally after every agenda item. Thank you.
Okay, thank you, moderator. I would now like to call the meeting to order and ask Christina to call roll to establish a quorum.
Good afternoon. I'd like to introduce you to Julie Weddle. She will be establishing quorum and taking any roll call votes today.
Good afternoon. I'm Julie Weddle. Christopher Jones,
Present.
John Sovek,
Present, LMFT, pronouns he, him.
Kelly Ranissing,
Present, public member.
and then for the record, Wendy Strack is absent and we have a quorum.
Thank you. Can you say your name one more time for me?
My name is Julie Weddle.
Julie. Okay.
Yes.
All right. Try. Take note of that. Board staff, would you please introduce yourself?
Steve Sodergren, Executive Officer, Board of Behavioral Sciences.
Hi, Marla McManus, Assistant Executive Officer for the board.
Roseanne Helms, Legislative Manager for the board.
Shelley Ganaway, Board Counsel.
Christina Kitamura, Administrative Analyst.
Julie Weddle, Enforcement Analyst.
And that's it.
All right. Thank you. Now it's time for the public to introduce themselves if they would like. This is voluntary. Is there anyone in the audience? Oh, sorry, John.
Quick question, just about something technical. On all of our names underneath it, it says unverified. Does that have any influence or effect on this recording?
Oh, good question.
Good question. No, it does not. It simply means that you do not own your own WebEx account under the DCA umbrella account.
That's correct.
Good question.
All right. It's time now for the public to introduce themselves if they would like. This is voluntary. Is there anyone in the audience that would like to introduce themselves?
Yes, there is.
Good afternoon, Shanti Ezrin. I'm the State Government Affairs Associate with the California Association of Marriage and Family Therapists.
Thank you, Shanti. Is there anyone online that would like to introduce themselves?
We have one more in person.
Oh, sorry.
Good afternoon, Divya Shiv, Senior Policy Advocate of Behavioral Health, the California Alliance of Child and Family Services. Thank you.
Thank
Okay,
you.
now we can move to online.
Thank you. This is the moderator. We do have a few people looking to introduce themselves, so I'll go down the list. Evelyn Beauchamp, I'm going to send you a request to unmute.
Hi, my name is Evelyn Beauchamp. I'm a licensed clinical social worker with Behavioral Health Reintegration, which is under the CDCR umbrella.
Thank you. And Sarah Carrasco, I'm going to send you a request to unmute.
Good afternoon, Sarah Carrasco, Licensure and Compliance Specialist with Jessup University. Thank you for having me.
Thank you. And Gina Beeman, I'm sending you a request to unmute.
Hi, my name is Gina Beeman. I'm a school psychologist, a licensed educational psychologist, and a licensed marriage family therapist. And I also am a executive member of CASP.
All right, thank you. Kathy Atkins, I'm going to give you a request to unmute.
Good afternoon, everyone. Kathy Atkins from the California Association of Marriage and Family Therapists. Thanks for having me.
Thank you. And let's see, last but not least, Ben Caldwell.
Good afternoon, everyone. Ben Caldwell, licensed marriage and family therapist. Good to be with you.
Thank you. And that looks to be everyone.
All right, thank you, moderator. Oops. The first agenda item is discussion and possible approval of the October 24th, 2025 committee meeting minutes. Does any member wish to remove or edit any of the items from the consent calendar? Be able to see you. No, we're okay. Then do I have a motion to approve the consent calendar?
John Sobek, I move to approve.
Do I have a second?
I second.
All right. Any comments from our in-person attendees?
No.
Any comments from our online participants?
This is the moderator. If anyone would like to make a comment on the board meeting minutes or anything else on the consent calendar, you may click the raise hand button to raise your hand, and each speaker will have 3 minutes with a 15-second warning. Any comments on the minutes? I do not see any requests for comment. I'll turn the meeting back to you, Chair.
Thank you, moderator. Julie, would you please take the vote?
Christopher Jones,
Yes.
Kelly Ranissing,
Yes.
John Sovek,
Yes.
motion carried.
Thank you. Next on the agenda is the discussion and possible action to make recommendations regarding possible statutory amendments to required notice to consumer requirements. Roseanne, would you please provide us with the overview?
Yes, thank you, Chris. So the board sponsored a bill back in 2024, which was called SB 1024. It became law in 2025, and it updated the procedures for licensees and registrants of the board to provide their license or registration information to clients. And the reason that the board pursued this change was because of the increasing use of telehealth, which made the physical display of a license outside of a traditional office setting impractical or impossible in many cases. So what the board did, instead of requiring the display of a license at the primary place of practice in all instances, the law now only requires the display at the primary place of practice when services are rendered in person, and it's at the primary place of practice, not a satellite place, to ensure that clients always have access to their therapist license information. What the board required instead is that the licensees and registrants must include their full name as filed with the board, the license and registration number, type, and expiration date. They need to include that with the required notice to consumers that must be given to clients prior to initiating psychotherapy services. And so this is intended to ensure transparency transparency while minimizing the administrative burden on licensees. Since the law has been enacted, however, there have been two different concerns that have emerged, two different potential unintended consequences. One of the things that has been brought to staff's attention is safety concerns for those working with incarcerated populations. So licensees who work with incarcerated individuals have expressed a concern that disclosing their full name and license number can pose a safety risk to themselves and their families. They might be particularly vulnerable to harassment or retaliation, and the mandatory disclosure of this information could increase these risks. We've heard from numerous licensees working with incarcerated populations who expressed serious safety concerns, and so in response, staff committed to bringing these concerns to the committee for discussion and consideration. And then the second concern is the scope of the disclosure requirement. There's confusion among some licensees regarding when the notice must be provided. The law states that the notice must be provided, quote, prior to initiating psychotherapy services. Questions have arisen whether the intent is to provide the notice only when actual psychotherapy is being conducted or when any activities within the scope of practice of the licensee's profession, such as the assessments, consultations, are provided. And as an example, a few weeks ago, I got a question from a licensee who wrote to request clarification because she's working for a mobile crisis response program. So she noted that the clinicians are not initiating an ongoing psychotherapy, but responding to acute psychiatric crises in the field in the context of crisis intervention. So they're doing safety assessments, stabilization, de-escalation, and service linkage. And so her question was, as these instances don't involve weekly sessions or voluntary informed consent, did she need to provide the written notice? So those are a couple of the concerns, the two concerns that I'd like to discuss today. I'll loop in what the Board of Psychology currently requires. In looking at their law, they also have disclosure requirements. Psychologists must provide their name, license type, and their highest degree earned, either in writing at the initial office visit or prominently displayed in an area visible to patients in the office. And that's in Business and Professions Code 680.5, which applies to several types of healing arts licensees under DCA. That particular law does include an exception for certain facilities licensed under Health and Safety Code Section 1250 and 1265. And the exemptions include general acute care hospitals and psychiatric hospitals, correctional treatment centers, and nursing facilities, although they appear to be more inpatient settings rather than just seeing a therapist for a visit at once at this place. If they were in prison, it doesn't seem to apply to somebody who would be just seeing a therapist there incidentally and not in an inpatient setting. Anyhow, that's what is required for psychologists. So we initially, this committee had discussed this issue at its October meeting, and it directed staff to reach out to some relevant agencies within the criminal justice system to obtain more information. So we reached out to several agencies, didn't have a lot of luck getting responses. We reached out to the state hospitals, the Inspector General, Board of State and Community Corrections. Didn't get a response there, but we did hear back from the California Correctional Health Care Services, known as CCHCS. And they oversee medical, dental, and mental health care for individuals incarcerated in all of the California Department of Corrections and Rehabilitations, or CDCR's, 31 institutions. They responded with detailed feedback and also had us speak with their legislative division. So CCHCS confirmed that historically mental health providers in CDCR facilities typically identify themselves verbally using their last name and professional title, Mrs. Jones, LCSW. Written materials only generally include the last name and title unless otherwise required by law. This is to minimize risks of harassment and retaliation. They note that they have a healthcare grievance process and supervisory review mechanisms that allow leadership to identify the provider even when the patient does not know the full legal name. And in the case of complaints made directly to the board, they can assist with the board in identifying the provider. They echoed concerns about the requirement to disclose full legal names and licensing details, noting that while they have some tools to protect privacy, such as institutional addresses, utilization, or mailing services, they don't fully address the risks imposed by mandatory written disclosures. We had the CDCR Legislative Office review the text of the proposal we are presenting today. They have indicated that they have not received any concerns from their program experts to date on the language, and stated that if the proposed language is adopted, CDCR already has processes in place to ensure clients are able to receive appropriate disclosures consistent with ethical clinical practice and taking clinician safety into account. So in terms of the proposed language, we've drafted some language shown in attachment A. It uses a provision in Business and Professions Code section 680 as a model. That language sets a name tag requirements for certain healthcare practitioners, but it allows discretion in certain settings to make an exception for individual safety concerns. So in utilizing that language, we kind of looked at that exception and then tailored it a little bit to our needs. So the draft that you're seeing today exempts from the disclosure of the name, license type, expiration date, a facility licensed as an acute psychiatric hospital pursuant to Health and Safety Code 1250B. And I've included the full text of that in an attachment. A correctional treatment center licensed pursuant to Health and Safety Code 1250I, again, shown in attachment B, but those are more inpatient settings. So we wanted to cast a little bit of a wider net to incorporate all incarceration settings. So we included some language that exempts any setting where mental health services are provided to incarcerated individuals under jurisdiction of local, state, or federal correctional authority, including but not limited to state prisons, county jails, juvenile detention facilities, or other correctional settings operated or under contract with a government entity. And then the language, and to ensure that there's a process in place for the incarcerated individual to file a complaint, we added language that the employer or agency may only exercise the discretion to not require the name and personal information be provided if the facility has an established process by which the client may request and obtain sufficient identification information to file a complaint with the board, and this process is disclosed to the client as part of the required notice. And that copy of the notice must be preserved with the client's record to prove that this was done. So that's kind of the first piece of the discussion. I also would like to have a discussion about the scope of the disclosure requirement and whether we need to, whether the requirement to provide the notice prior to initiating what the law calls psychotherapy services is intended to just apply to an ongoing psychotherapeutic relationship, or if it is intended to apply to any services where a licensee or registrant is working within the scope of practice of the profession. And clarifying amendments should be discussed if they are determined to be needed. So I'll open it up for discussion at this point.
Any comments from the board, from the committee? Kelly's thinking.
I guess one of my concerns is that, you know, there's been an expansion of practice outside of the traditional clinical office role in therapy, you know, into more acute settings where they don't formulate that therapeutic relationship as formal as one might do if they're coming into an office and establishing weekly therapy or monthly therapy. So to what extent does that affect the notice that they have to give based, and I see what Roseanne was saying about the primary place of practice, because they're not really formulating an existing therapeutic relationship. They're providing acute services. That's kind of an interesting question.
And also following up with Kelly's thought, when we're looking at this scope of disclosure, even if someone who's being treated in a crisis response situation, do they not also have the right to have access to the information in case something in that crisis situation was managed poorly and they want to file a complaint?
Roseanne, did you have a response?
I don't really have a response. Those are two good questions that I think that we should discuss. Possibly instead of saying, you know, something like upon initiation of psychotherapy services, we could say prior to providing services within the scope of practice of their profession, or something like that would make it clearer, because what I'm hearing is that people are either thinking it's just when they're providing ongoing weekly psychotherapy, or if it's unclear if they need to provide it, whether or not in the instance of other types of services being provided that are in the scope of their license.
All right, any other thoughts or questions from the committee?
And then Roseanne, in regards to the incarcerated population, it sounds like doing that slightly deeper dive provided us with a lot more information. And I think the way we're going with it, what you've crafted as the proposed language sounds really on track.
Okay, good.
So thank you for that.
I would agree. I think this is, I mean, it's very difficult because we're asking Roseanne to come up with a solution to two very large, difficult questions. So thank you. And I agree with John.
Yeah, this was the best solution that I could come up with. I mean, we're never going to be able to 100% guaranteed do all incarceration settings have a great, you know, file a complaint process. We're never going to be able to audit that. The board doesn't have purview to make that determination necessarily, but we can put steps in place to ensure that they are vouching that they do, and they have documentation to prove that they provided that person with the process that they have to file a complaint with the board.
And I concur with both of the other committee members. So, so at this point, we'll take comments from our. If there's no more comments from the committee, we'll move to comments from our in-person participants.
We have some. Hold on.
Hello, Shanti Ezrin with CAMT. Roseanne, thank you so much for bringing these concerns to attention and for your additional research on the complaint process within correctional agencies. So based on your research and then what you provided in terms of the model that the Board of Psychology has in handling similar circumstances, CAMP doesn't have concerns with the proposed language that makes an exception to this. We appreciate that the language is narrow in its settings, while also subdivision A3 is crafted in a way that would allow other settings that work with incarcerated individuals to fit under this exception as well. Now, as it pertains to the scope of disclosure, we appreciate hearing the discussion today, and we'd agree with the committee member comments that it seems to be helpful to identify maybe different examples and evaluate the board's intention with each. So some examples that come to mind include, Roseanne, what you had shared about MFTs who work in mobile crisis settings and provide services under that context, which are not typically ongoing psychotherapeutic relationships, as well as other acute settings that were brought up. And another one comes to mind is those working in like disaster response teams. And then, of course, there are examples on the other side of the coin, like MFTs working with students in school settings, et cetera. So I know right now it seems to be a open discussion. CAMP would be happy to be a resource to the board on this and provide more examples, more information, whichever would be most helpful to the board and staff in determining if clarifying amendments are needed. Thank you.
And that's it for in-house.
Excellent. Do we have any comments from our online participants?
This is the moderator, and we are opening for public comment from people logged in through WebEx. As a reminder, you can click on the hand icon to raise your hand, and each speaker will have 3 minutes with a 15-second warning. We do have a request from Evelyn Beauchamp, and I'm sending you a request to unmute.
Hi, as mentioned, my name is Evelyn Beauchamp. I'm a social worker with adult parole behavioral health reintegration, and I've also worked at Coalinga State Hospital. With Coalinga State Hospital, the population that we serve are sexual violent predators, and they were savvy enough to be able to find some staff members' addresses and send cards, send flowers, and send letters with grotesque information in it. So none of their seeking out personal information was to make any complaints, because their complaints would immediately go to, if they had them, the social workers or the psychologist supervisor. And so one of my questions is, are you asking for the client or the patient to surpass that trajectory and seek advice or a remedy from the Board of Behavioral Sciences, which would take longer than to just go directly through the normal chain of command, which would be the social worker supervisor? Now, currently, as I mentioned, I'm working with the Board of Behavioral Sciences with parolees. And of course, we have our license posted in the office, but presenting to them might create more conflict or more disruption than it would um, cohesiveness to the therapeutic alliance that we're creating. If there is no problem and you're presenting here, this is the information. If you have a concern with me, please notify this Board of Behavioral Sciences. It just creates a setting, an environment where it's almost like you're predicting that the relationship or the rapport with this client is not going to be a therapeutic one. Um, these clients know how to seek assistance. They're very savvy, and most of them that aren't savvy, because some have mental illness, they have support through their parole agents. So I think that this remedy for providing the client with some type of outlet to report um, illegal or an unethical treatment is not the correct way to go with our population. Thank you.
And I do not see any further requests for comment. Shall I close? Oops, I misspoke. We have Al Austin. Al, I'm going to send you a request to unmute, and you'll have 3 minutes.
All right, thank you so much. I'll be short. I'm Al Austin on behalf of the American Federation of State, County, and Municipal Employees. We are the exclusive bargaining representatives for most of the mental health professionals who work for the state of California. Bargaining Unit 19. We represent psychologists as well as licensed clinical social workers, MFTs, licensed professional clinical counselors, as well as most of the mental health um, classifications in the state. And I'm here to just state support for the recommendations from staff. We've had some conversations leading up to this meeting. We encourage the committee to support the cleanup amendments to SB 1024 that we believe will restore safety provisions to the mental health therapists who work with incarcerated populations across the state, both in the state settings, but also county and municipal settings as well. That is my comment.
Thank you. And we have one more commenter, Angela Martinez. I'm going to send you a request to unmute.
Hello, good afternoon. My name is Angela Martinez. I'm the Associate Vice President for Exodus Recovery San Diego's programs. One of our programs is contracted with the County of San Diego to provide mobile crisis response. So we have mobile crisis response teams. And if I'm understanding correctly, I think it's being proposed that the language be changed to capture a wider range of services. But I would say that when we are having to provide this information during a crisis intervention, some of the things that can happen, number one, a lot of the times, most often, the client is not requesting services. So it could be a community family member. The client is not requesting services. So they are already in a crisis. They could be agitated. They're not requesting services. We have seen definitely a clinical interruption. So asking our escalated clients to acknowledge or, having to provide a license, client confusion. We had one client think that the therapist or the clinician was offering their phone number. And then also we are enacting 5150, so placing, people on holds as appropriate. And so, as you can imagine, that could likely increase, the possibility of a complaint because someone was put on a 5150. So, I mean, that is the lesser of the concern, but more often it's just a clinical interruption of having to kind of go through this process during when a client is in crisis. So I would advocate that, that also needs to be taken into consideration, kind of piggybacking on, I don't remember the woman's name who spoke first, but I'm not sure that this is the correct way to provide a client an avenue for complaint. We're contracted with the County of San Diego, so like any of our other outpatient behavioral health clinics, everyone has, the county provides guidelines of how a client or a participant could navigate a complaint. And so I guess what I would be advocating for is in some scenarios that the client would be referred to other avenues of, making that complaint. Thank you.
Thank you. And I do believe at this point do not have any further requests for public comment. So I will turn the meeting back to you, Chair.
Thank you, moderator, and thank you for the comments from both our in-person participants and our online participants. So at this point, Roseanne, it feels like we have more work to do to look at the language.
Well, I mean, I'm hearing that there's support for the new section, the 4980.33, and we'd need to draft that for the other license types. But I'm hearing generally support there. I think the question becomes the prior to initiating psychotherapy services, and whether the committee wants to keep that language or expand it to say something like within the scope of practice of the profession. I think those are kind of the main choices. Maybe I don't know that we want to do a bunch of setting carve outs because that can get confusing to individuals. Like we have the private practice versus professional corporation. Like when you have different settings, then there tends to be a lot of gray areas. The reason that the as soon as practicably possible thereafter language was meant by the board when we crafted that language for crisis situations so that they don't need to stop what they're doing right away and wait to provide the notice or to provide the notice right then and there when they're in the middle of the crisis. They can provide that later if needed. But yeah, I think that's that's the main sticking point, is the initiating psychotherapy services. So if you want to continue that discussion, we can.
Roseanne, this is John. I have a question about that. So when did this 1024 go into effect?
This went into effect the law went into effect January 1st, 2025. Well, the requirement to provide the personal information, the notice to clients has been in effect for several years. I would say around 2020, probably.
Mm-hmm. So my thought is that the safety and concerns working with incarcerated populations, we've had a direct reach out from the professionals who work there who have asked us to make some changes, which all sound incredibly valid to me. The scope of disclosure requirement, I'm a little leery to start changing the language when we're finding that the questions are few and far between, and maybe they just need to be fielded as part of the implementation of this law. It does take a while, and as therapists, suddenly we're engaged in a new situation, and these questions will come up as it goes along. I'm not sure if we need to rush into changing it in response to what might still just be a learning curve. Do you have any thoughts on that?
I do. I think that's reasonable. The heavier question, and the one that seems to be more urgent, is really the practitioners who are working in correctional settings. The other goes kind of in tandem. While we're working on the language, this question's come up. I think that it's definitely something we could monitor over time and see if it needs further clarification. But the correctional facilities seems to be a more urgent need because it's affecting people in that field.
And so, Chris, is this a motion-based moment, or is this just, Roseanne, you're on the right track, go ahead, bring it to the full board. What is this required right now?
Well, that was my thought also, that I don't know that we have a motion here.
I think it's
Kelly?
direct staff. I think you can just direct staff to make, what we've talked about, the changes. You got it.
I can suggest the motion. Would you like me to do that?
Sure,
the
one
motion
second.
I would like, if we're going to use one, is to go with working on the incarceration one, and that's the one I want to address. I don't want to continue the conversation about the disclosure piece yet.
Okay.
So I think that the motion would be, because we're not proposing any changes to the psychotherapy services wording right now, I think the motion would be to proceed with the language in attachment A as written. I have one clarification I want to make to that language, and then to draft for the other license types. Chris, I need to know if we should draft it for LEP. And then to bring to the board in February for consideration as a legislative proposal.
I so move.
Okay.
Well, Kelly also had a question too. I want to make sure that we get that in there.
Well, no, and I'll second the motion. The only thing I was going to mention is on the incarcerated population question, and that is, I understand the concerns of the correctional officers and the correctional employees and the very courageous therapists who work in correctional settings. One thing I do not agree with is that we can never restrict a client from contacting the board. All clients have the ability to contact the regulatory agency. That is core of our public protection mandate. They have the ability to speak with us. So to the extent that anything chills that, that they want people not to contact the board and just speak through the chain of command, I do not agree with that in any sense. So that, as long as that's out there, I'm fine with the motion. And I think more research needs to be done, but we cannot chill our public from contacting the regulatory agency. That's it.
I don't think it does. So the in B1 of the language, it says it requires that the facility has an established process by which the client may request and obtain sufficient information to file a complaint with the board. So I'm trying to think through if that's clear enough. I believe that it is. I don't believe that there's a chilling effect there.
So, and as long as there is a mechanism for the client to directly contact the board and then the board to communicate with that agency to get the identifying information, that's fine. But I don't want to put another step in front of the client before being able to contact the board.
Yeah, I think that this accomplishes that. It's just that they have to go through an extra step to get the additional information in terms of the name and license number. And then there has to be a way that they and so that they can get the information to file a complaint. Steve's saying, yeah.
No, I agree with you. I mean,
Does that make sense, Kelly?
I guess my concern is what if they don't give it to them?
Well, they can still file a complaint with BVS.
Yeah, exactly.
Yes,
and then
they can still file a complaint with us, and then we would have to contact them to find out that information. If say the incarcerated individual did not have the information, we would contact CDCR or whatever facility.
And see, that's what I was getting at with that subdivision where it says the client. I would just include a word in there that says the board can contact the agency too, because if they file a direct complaint, you know, we also have to know who that person is, but we should not leave it up to the client if that information has never been given to the client. Do you get what I'm saying?
yeah, that would be part of the investigative process. I mean, we would, if we got a complaint that came in, we would look to that agency and contact them. So it's an inherent in our enforcement process. I don't know if that, yeah, I mean,
and that satisfies me. Yeah.
And to answer your other question, Roseanne, yes, please include LEPs because we sometimes work in juvenile facilities.
Okay, perfect. And then I wanted to just point out one other minor change that I want to make to the language. In subdivision A, the very last sentence where it says the discretion may only be exercised when the licensee or registrant is providing services in one of the following settings. I want to change the discretion may to the discretion shall. So I'll include that in the draft.
Okay, great. Thank you.
And
we have a.
Oh, sorry. Go ahead. Just because we have a motion now, we do need to open it up for public comment again.
That's where I was going. Now,
Thank you.
Now that we have a
Sorry.
motion and a second on the floor, we need to open it up for public comment again. So thank you. Do we have any comments from our in-person participants?
No.
Do we have any comments from our online participants?
One moment and I'll ask. This is the moderator. If anyone would like to make a comment on the motion or the issue, you may look for the hand icon and click that to raise your hand. And each speaker will have 3 minutes with a 15-second warning. If you're on a mobile device, that hand icon might be behind the 3-dot other options. Any comments on the motion? I do not see any hands raised, so I will turn the meeting back to you.
Thank you. Okay, Julie, would you please take the vote?
Okay. Chris Jones,
Yes.
Kelly Ranasing,
Yes.
John Sovek.
Yes.
Motion carries.
Thank you. Next item on the agenda is the discussion and recommendations for possible statutory or regulatory amendments to address licensees' use of artificial intelligence. Roseanne, would you please provide us with an overview?
Yes, we wanted to start this conversation because we've been doing some work behind the scenes regarding gathering information about artificial intelligence in therapy and also researching some other states that are starting to act. So this is kind of informational, and then we can discuss where to go from here. The use of AI, of course, as you know, becoming more widespread in therapy. and there's been more discussion about the role licensing boards should play in its regulation. So recently, the California legislature took an initial step in this area. AB 489, which was recently signed by the governor, prohibits a person or entity who develops or deploys an artificial intelligence system from having that system represent or imply that it is a licensed healthcare provider by using prohibited terms, letters, or phrases, and it makes violations subject to the jurisdiction of the applicable licensing board. And this bill is significant because it gave the board the authority for the first time to take action against a business entity instead of just an individual. So in terms of moving forward, regulating the use of AI is going to require striking a balance between avoiding overregulation that could stifle future technologies with it that haven't emerged yet, while ensuring the public is protected from being misled or harmed. So it may be prudent for the board to consider adopting regulations similar to those currently that the board has governing advertising and the use of telehealth, so that licensees and registrants have clear guidance on safe practice and disclosure requirements. To gather some more information about this, in November, the board staff hosted a listening session on WebEx. It was called BBS Lunchtime Listening Session, Artificial Intelligence in Mental Health Practice. And the purpose was to gather more insight and perspectives of professionals on the use of AI in mental health practice. It featured a panel with representatives from CAMPS, NASW California, and the California Alliance of Child and Family Services. Panelists responded to questions developed by staff addressing the potential benefits of risks of AI use in mental health and ethical considerations relevant to practitioners, educators, students, and trainees. And feedback was positive and indicated a great interest on receiving additional ethical and legal guidance from the board regarding using AI in mental health. And I've included a link to that listening session that was recorded and posted on our website. So the link can be found in your packet if you're interested. There's been a lot of different organizational efforts across the country to explore AI in mental health treatment. The NBCC has put together a document that compares AI guidelines in professional counseling. And so you can see that in attachment A. The American Association of State Counseling Boards has created a document that I've included in attachment B that's intended to support state licensing boards in their public protection duty as AI becomes more widespread. There have been a number of state efforts, so a few notable ones. The first one to sort of lead this effort was the state of Illinois in August, that they signed into law the Wellness and Oversight for Psychological Resources Act. That law prohibits any person or entity from offering therapy by any means other than a licensed professional. AI may only be used to provide administrative or supplemental support. The law defines administrative support as a task to assist the licensee in the delivery of therapy that does not involve communication. So managing appointment schedules, reminders, or billing and insurance processing. And then supplemental support is tasks that are not therapeutic communication, and then they're also not administrative support. So things like maintaining client records and therapy notes, or using data to track client progress. And then if the therapist is using supplementary support, then their law says that they need to require specific client disclosure and consent. So that's in attachment C. Pennsylvania has a proposed law right now that's very similar to Illinois. And so I've included the text of that. Florida also has a proposed bill. It's somewhat similar. It has a little bit different requirements. And then Nevada has a law that was signed, that's in place, that basically says if the therapist uses AI for any authorized purposes, they need to make sure it applies with all applicable state and federal privacy and security laws, and they also must independently review the accuracy of any report, data, information compiled or analyzed. So that particular piece of that requirement for Nevada reminds me a little bit of our telehealth laws, because we have something about being in alignment with privacy laws and also certain disclosures and things like that. So like I said, this is just sort of the beginning of an ongoing discussion of where we're going to go with this. So with that, I'll open it up for comments.
I like the direction that we're going. It does feel a lot like the telehealth explosion that we had in 2020. You know, in our experience, at least within our organization, AI is becoming a big tool, and I think we need to look at putting some regulations in place that will make sure that there's ethical use of it. Because I know that anytime that we have a new technology that explodes the way that AI is exploding, that we'll need to give guidance on how to make sure that it's used ethically to protect consumers. That's from our committee. Kelly.
I like Illinois' example. I think it's tailored enough to allow further growth, and it offers some examples for what AI can be used for. I mean, I think it's a well-crafted law. I don't know if you agree, Roseanne, but it looks quite helpful to me.
I do. I think it's a really good starting point. I like the definitions of the administrative and the supplemental. I also like some of the components of the other things that do certain things with, I think that in the listening sessions, there was a lot of desire for more guidance. And so I think the administrative and supplemental, having definitions like that would be helpful. I also think that's the things sort of like what we did with telehealth, like making sure you're complying with federal privacy laws, sort of having like a checklist that they have to do before they use it, making sure that you review something that AI spits out to help you in your therapy. Like those might be helpful. We can talk like further if that's an item we would want to put in a regulation, or what main things that we want the practitioner to do. And I think Illinois is a good starting point. I'm hearing demand for a little bit more specifics too. But yeah, I agree.
John?
So this is John. I also think Illinois is a great stepping off place. I also suggested the first paragraph you shared of Nevada's is another really good piece to add to how we're building our language. The other thing that's really interesting to me is the AASCB attachment. It's definitely, they've thought through some things that were right at the, the beginning of covering. But when I look at that, and especially what they suggest as a potential informed consent with AI support, there are lots and lots of concerns in there as to how practitioners are going to be able to maintain some of those standards. Putting things there about data collection and secure storage and pieces like that, and a consent piece, people are still on the edge all the time, just trying to manage daily records. So I would suggest our language starts off with a combination of Illinois and that first paragraph of Nevada. But then we also look at that informed consent, Appendix A, or it's Appendix B, but in their thing, it's Appendix A, the informed consent, to really look at where we might need to focus and tighten things up to make sure our clinicians are able to live up to these standards. Does that make sense?
So yeah.
I think so. Because when I read the AASCB document, the concern that popped into my mind when it was talking about like data storage and think like it's a little bit confusing to at least to a layperson like me, and probably a lot of our therapists who are not really techie people. Like, how do you actually ensure that? It sounds kind of fancy and scary. So
It
yeah,
sounds good, but it's almost impossible to achieve for someone in a private practice.
Right.
And even in community work and stuff like that, I think it's a bar that would be almost impossible to guarantee.
Okay. Yeah, so I think that we can kind of using Illinois and Nevada as a model, and then looking at that and looking at our telehealth regs kind of as a base, and seeing like, that regulation has certain line items you need to do A, B, and C, and like seeing what we can plug in from all of those documents into that to get a telehealth like regulation for AI. So yes, I think I know where you're going with that.
Thank you, Roseanne.
All right. Any other comments from our committee members? No. Okay. How about comments from our in-person participants?
Yes, we have a few.
Hi again, Shanti Edrin from CAMPT. Wanted to thank everyone for tackling this topic of AI. And I'll start just by recognizing that this is a very hard topic to address because the nature of things with AI just changes very quickly. Technologies are definitely still emerging, and we're all still very much learning about AI. So something that could be true about AI today could very well change the next. That being said, we do believe there is a need for guidance, and doing something on this is certainly better than doing nothing. So I'll just end by sharing that at camp, we've also been doing a lot of work around AI. Just recently, our board of directors approved revisions to our camp code of ethics, specifically to address the use of technology, telehealth, and AI. So we're happy to be a resource to the board, of course, and happy to share the resources we've developed on AI so far as, we all work together to potentially put out some regulations on this. Thank you.
Thank you.
Hi. Hi, Divya Shiv from the California Alliance of Child and Family Services. Just echoing Shanti that, we really appreciate your involvement in this very important, time-sensitive topic. We are also engaging more in AI as it relates to behavioral health, and we've started an AI and behavioral health work group to address this issue. So also happy to be a resource as applicable, and just really appreciate the BBS for taking this issue on as it is just so critical. Thank you.
Thank you. Any comments from our online participants?
We do already have a couple raised hands, so let me announce if anyone would like to make a comment on this issue, you can look for the hand icon and click that to raise your hand. Each speaker will have 3 minutes with a 15-second warning. So starting from the top, we are at Ben Caldwell. I'm sending you a request to unmute.
Thank you. Good afternoon, Ben Caldwell, MFT. I also appreciate the committee's effort and the board's effort to look into these issues surrounding AI. It is indeed a very fast-moving topic area. I want to give a lot of credit to the folks at CAMPT for the actual changes that they have made to their ethics code to address artificial intelligence in a way that I think avoids overreach and is achievable for practitioners. Like it makes sense, it is applicable, it is achievable. And I wanted to suggest that the board maybe take a look at those principles as guiding in regulation that might be, I think, Roseanne, you said, a telehealth-like regulation for AI. I think it's a great framework. The changes to the CAMPT code emphasize, in my mind, kind of three principles. One is disclosure, that clients should have a right to know when AI is being used. Another is consumer choice, that they should have the ability to opt out from the use of AI in care delivery. And the third is accountability, that the clinician remains accountable for all the clinical choices and documentation that are being done under their name, under their signature. One of the bills that the legislature passed last year was Assembly Bill 316, saying essentially that a defendant can't blame AI for harm that was done to another person using AI. And I wonder whether, as part of this process, we should consider applying that same principle within disciplinary proceedings. If somebody has a complaint or some kind of accusation against them that is related to their clinical use of AI, we don't want that clinician to be able to sort of push off the responsibility for any harm done and say, no, it was the AI that did it and not me. I think clarifying that in regulation could be really helpful. Also, want to offer to be a resource if there's anything I can do to be helpful with research guidance along the way. I'm happy to do so. But the CAMPT principles are really great places to start. Thank you.
Thank you, Ben.
Thank you. And our next request for comment is from Gina Beeman. Gina, I'm sending you a request to unmute.
Hi, thank you. I know that I only have 3 minutes, so I do want to echo everyone's efforts to address this issue in AI. It's infiltrated every area of our profession, of every profession actually. And CASP, we have begun to chip away at this issue to include updating our code of ethical conduct and starting in an education and mental health work group, AI work group. This is a huge thing. It's a great deal to consider regarding AI and mental health services. Um, and I believe that starting with an informed consent, like you guys were talking about, is essential. But I also think that it's important to prioritize AI literacy and digital citizenship training for providers, and help providers also give that to their clients, at least some basics. I think this dual approach can help ensure that everyone involved really understands that technology, at least the basics, its limitations and their rights. And laying a strong foundation for responsible AI integration. I think that is one of the key foundational points.
All right. Thank you, Gina.
Thank you. And our next commenter is Daniel Navasarchin. Sorry about the name.
Hello, good afternoon, everyone. My name is Daniel Navasartian, LCSW. I work for a large behavioral health agency that provides services in several counties in California. I also chair our AI governance board. I want to first start by just thanking the committee in tackling this very important issue. I know it has many pieces, and I just would like to offer some feedback and suggestions about where our group is looking for guidance and support. In the area of informed consent, it would be helpful to continue discussions like this around guidelines about the type of language that's required for that consent, along with the actual use cases that the clients could be consenting for. Popular with a lot of the vendors is documentation support, but there's other use cases that might require consent, such as analysis of treatment data, developing handouts for sessions, um, clinical decision support. And so it would be helpful as this discussion evolved to receive guidance around the approved and ethical use cases of AI. In addition, one of the challenges in serving many different counties is that each county is starting to develop a slightly different posture around the use of AI and what it requires to gain AI approval. And so one of the items we're working on now is, as we look at different products and different vendors, what are the key questions we need to be asking our vendors to ensure that we're moving forward in a safe, secure, and responsible way? And so, both on the community mental health side and also private providers, it would be helpful to develop some guardrails and guidelines around questions to ask vendors about their products to ensure, just like telehealth, just like EHR systems, that these AI solutions have some key baseline requirements to ensure that they're secure, unbiased, and can be used responsibly. I'll close with just saying I'd also like to offer to be available for any support or feedback in this area. And thank you again to the committee for spending the time on this.
Thank you.
And that does conclude the last of the comments. Last call, if anyone would like to make a comment on the issue. I do not see any other raised hands, so I will turn the meeting back to you, Chair.
All right, thank you, moderator. Anything further from our committee members? No? Okay. Roseanne, thank you for all of the hard work that you're doing to, to put us on this journey. And at this point, I think that we're just going to continue to look at the information, correct?
That is correct. We'll continue gathering information and looking at things that might go into a regulation and we'll report back at a future meeting.
All right, thank you so much. Next on the agenda is update on board sponsored legislation. Roseanne, back to you.
Thanks. So we have two legislative proposals that we are pursuing this year. The first, as always, the board committee bill or omnibus bill, which is technical or non-substantive amendments. We've submitted several board approved pieces of language for inclusion in the committee bill this year. So basically they're clarifications when supervisors must assess for appropriateness of using video conferencing supervision, some modernization of statutes and correction of section numbers. So look for that to introduce within the next couple of months. Also, the second bill proposal we are pursuing is the amendments to restructure the licensing pathways. This is the proposal that removes the requirement for associates to attempt the California Law and Ethics exam every year to renew their registration. It puts an age limit on the California Law and Ethics exam. It has some clarifications for faith-based counseling. It increases the amount of time supervised experiences hours remain valid from 6 years to 7 years, and the length of a registration number from 5 renewals to 6 renewals, and then allowing associates with the subsequent registration to request a one-time 2-year hardship extension to work in one private practice setting. So I'm happy to report we have a bill author for that, and it will be introduced within the next couple of weeks. So at the board meeting in February, we will have a bill number to announce for that. And that's it.
That's great. Thank you, Roseanne. I'm glad that we were able to get an author. That's fantastic. Any comments from the committee members? Any comments from our in-person participants?
Nope, none here.
All right, thank you. Any comments from our online participants?
This is the moderator. If anyone would like to make a comment, you can click on the raise hand button and each speaker will have 3 minutes with a 15-second warning. Any comments on the issue? I do not see any requests. I'll turn the meeting back to you.
Thank you, moderator. Okay. Next on the agenda is update on the board rulemaking proposals. Christy, would you please give us an overview?
Chris, Christy isn't present and we didn't post the materials for that, so we would like to skip that if that's okay with you.
Okay, sounds like a plan.
Thank you.
And then we'll move on to the next agenda item, which is suggestions for future agenda items. Do any committee members have additional agenda items for future board meetings? Okay. Do any of our in-person participants have any agenda items for future board meetings?
No, none in-house.
No. How about our online participants? Any agenda items for future board meetings?
This is the moderator. If anyone would like to suggest a topic for a future meeting, you can click the hand raise button. Are there any suggestions for topics for future meeting? I do not see any raised hands. I will turn the meeting back to you.
Thank you. Next item on the agenda is public comment for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during the public comment section, except to decide whether to place the matter on the agenda of a future board meeting. Do any of our committee members have any comments for items that were not on the agenda? Do any of our in-person participants have comments for items not on the agenda?
There are none in-house.
And do any of our online participants have any comments for items that are not on the agenda?
This is the moderator. If anyone would like to say anything that was not on the agenda, you may click the hand raise icon to raise your hand. Any further comments that were not on the agenda? I do not see any requests. I will turn the meeting back to you.
All right, thank you, moderator. Our next agenda item is adjournment. Thank you everyone for participating today. As a reminder, the next board meeting is will be on February 19th and 20th up in Sacramento. We hope. Thank you so much and have a great rest of the day.
Thank you all. Have a good day.
John, Chris, I'll see you both in February.